Part 2, July 30th, 2024, new Sitzer NAR settlement forms, practical practice tips, and NAR FAQs every agent must know. We'll go through this quickly. Quick update
Just
on the
to let
form.
everybody, I would just let everybody know we did a great webinar on this on our last webinar 2 weeks ago. There is a recording on YouTube on it, and this is an update from that, webinar. So this is great, Jim.
Are you guys able to see the small print on the outline?
Yep. No, we can see it.
You can see it? All right.
Yeah. There we go.
All right, so there's 4 new broker compensation agreements that were released a few weeks ago. We've gone over this stuff in detail. That's the agreements. Exclusive brokerage agreement, single agent, non-representative, transaction broker, and former broker compensation agreement forms were released 4 weeks ago. There's more on this below. We reviewed these forms in depth 2 weeks ago. We did our first closing. Oh, the Tajay will appreciate this. We did our first closing the other day, and we had an agent come to the table, and the agent got 2.25 from the seller, and the buyer paid 0.75. There was no apparent uphill. Nobody complained. The agent did, Tajay, if I say something not correct, intervene. It was smooth and all was spelled out in the DA that the brokers sent over. There was a disconnect. There was a disconnect in value. Oh, if there was a disconnect in values, it would be up to the brokers to work it out. The title agent can't give an opinion. Many agents have told me that they will send their agreements to the title agent and let them figure it out. I've heard from many agents that they're going to take their agreements and they're going to send them to the title agent and tell the title agent, if there's a disagreement or there's something, you figure it out. The way it has to work is the agents have to come to agreement. If you're using the seller's comp form, which we're going to go over in a second, those forms have to be agreed to between all the parties before you or while you get into closing. I have no problem if you guys text me helping you figure this stuff out. But it's not like if you're using any title agent, you send the forms that you've had signed into the title agent and say, put it on the HUD. It has to come in the form of a DA, a distribution authority coming from the brokers. Is that clear?
So the brokers, do you want it like both the brokers have one agreement that they're all signing, or they each send their own DA?
They're each going to send their own DA.
All right. And it's going to spell out there, hey, I'm getting 2.25 from the seller and 0.75 from the buyer. Then you reflect that on the HUD.
And then the DAs have to be not conflicting.
Yep.
The seller's agent DA can't conflict with the buyer's agent DA. There's 4 new broker compensation forms, buyer's broker compensation forms. They just came out. We'll go over them today. There's a pre-touring agreement. We'll go over that today. And we're still, most importantly, not most importantly, but very important, we're still waiting for the updated listing agreement with the mandatory Sitzer language. Due out August 1st. We'll cover them as soon as they've been released. There's a disconnect between our local association and the state association as to when this stuff is coming out. But from the nearest I can gather, it should be August 1st. They will contain, how do you know you're not using the new form? The easiest way is because the new form is going to contain language, something similar to the mandatory Sitzer language, which is commissions are not set by law and are fully negotiable, like we see in all the buyer's rep agreements that are out now. Expect to see this language, we'll call it Sitzer language, everywhere that the agent's going to sign, that the buyer or the seller is going to sign something that has a commission in it. I hate to say I told you so, but I think if we had done this back in 2018, 2019, when all these lawsuits started to be filed, we wouldn't be where we are, regardless.
I thought it can't be compensation. It's it can't be commission. It's supposed to be compensation now.
I've heard, we talked about this last week, and I listened to the Florida Realtors attorney talk about this. There's a video link I left you guys that you can watch it. It's dry as dry can be. It's 12 minutes long, and they expressly state you have to refer to these terms differently. But then when you hear all the other officials talking about it, they're still talking about commissions and compensation and things like that.
My big question is like, who's enforcing this, and then what are the ramifications?
Yeah, we'll
Still,
go over that in a minute too. All right, so there's 4 new exclusive buyer brokerage agreements. Agents are calling me every day. Which form do I use? I called Florida Realtors and asked if there was a practical guide, and the answer is no. The form I've seen used discussed used the most is the transaction broker form. That's this one right here. How do I do this without clicking on
second one
a
down.
form?
There you go. That one.
Strike the last sentence of the protection period in paragraph 8. So in this form, when you use this form as a matter of course, take 2 seconds and strike the protection period extension. Guy Quattlebaum brought this to my attention several months ago. I never thought it would happen. And then an agent on this podcast showed me where they were cheated out of a commission. And I've heard from half a dozen agents since where they got cheated out of commissions. The protection period provision specifically says if your buyer and your agent cancel the agreement and the buyer goes out and hires another agent and they close with somebody you showed the property, you're cut off from your commission. Why is this important? Because everybody knows an agent. Every person on this planet knows a realtor and they're a friend. And if they want to get devious, all they got to do is, I'm the buyer. Ryan showed me a house and I love the house. And I say to Ryan, hey man, this isn't working out. Ryan is one of those agents who doesn't want to make friction. He lets me out of the agreement. And then tomorrow I go sign up with my best friend Tajay and give him whatever or nothing. And Tajay is now my exclusive buyer's agent. And I close with the buyer that closed the property that Ryan showed me while he was my exclusive buyer's agent. And I owe Ryan nothing. Trust me when I tell you, social media is so penetrative, if that's even a word. People are picking up on this stuff. As a matter of course, just take 2 seconds and strike that provision out of your contract. I'm telling you right now, there's an agent on this podcast that got burned by this, and it was 15 grand. Sorry to harp you guys. I'm passionate about
So
this
just
stuff.
strike out that last sentence in number 8.
Yeah, you want to strike out consumer's obligation to pay broker's fee ceases upon consumer entering into a good faith exclusive buyer brokerage agreement with another broker after termination. It says
Jim, what form is this again? Because we use a different listing from,
This is for the buyer's broker's agreement transaction.
oh, exclusive buyer broker agreement. Okay, gotcha. Thank you.
You are very welcome. Good question.
And it's horrible. They don't put it at the top, but you have to scroll down, Jim. Show it where it says the transaction. This is a transaction agent, because it's not up at the top and they all look the same. Just
All
scroll
the
down.
forms look the same.
It's
It's one of the most confusing things. And I spent 2 days, 2 weeks ago trying to figure all this stuff out.
Yeah.
So if you look at paragraph 12,
Oh, yeah.
it says broker will act as a transaction broker. If there's 4 forms, the one that I've seen used the most frequently is this form, and it's defined by that first sentence in paragraph 12. You can also define it by the way it's described in the forms library right here, where it says exclusive buyer brokerage agreement, transaction broker. Does the Florida Association of Realtors, Florida Realtors, give you a user guide that helps you with this stuff, a cheat sheet? I can't find it. I'm trying to provide that to you.
What do we cross out on number 8 again?
Paragraph 8.
Yeah.
You want to go to the very last sentence and you want to cross off the protection period provision that cuts off the first buyer's agent if they get another buyer's agent.
For 30 days, if you leave that blank. For 30 days. So you're protected for 30 days, Jim. I mean, would you want to?
I would suggest you write in there as long a period as you can get away with.
Mm-hmm.
You leave it blank.
I'm confused. I'm so sorry. So we want more than 30 days. We'll put like 120, let's just say.
Yeah.
And then I'm crossing off what line? striking out?
here.
Just highlight it,
Consumer's
Jim.
obligation to pay broker fees ceases upon consumer
Got it.
entering into a good faith exclusive buyer brokerage agreement with another broker after termination. Now, we could all say that if they sign up with another broker just for the purpose of cutting off broker A, if they sign up with broker B, that's bad faith. But that's an argument. Who wants to have arguments? My goal for you guys is do everything you can do prophylactically so you're not getting in arguments and you're operating efficiently. When representing buyers, there is Johnson v. Davis language now, which is seller's disclosure language in the buyer's brokerage agreement, paragraph 10. Please keep this in mind when you learn of problems with the property. Full stop, pause, let it sink in and marinate. So now there's Johnson v. Davis language right in the contract. Let's see, paragraph 10, dispute resolution. That's not it. Conditional termination. Did I put the wrong paragraph on there? I will fix it. There it is right there. Paragraph 12. Brokerage relationship. In the contract now that you're going to have with your buyer's agent.
With your buyers, if you're a buyer's agent.
I'm sorry, with your buyers, if you're a buyer, when you're a buyer's agent, it says that as a broker, buyer's agent broker, you will discuss, disclose is an affirmative duty, will disclose all known facts that materially affect the value of the residential property which are not readily observable to buyer. So there's three elements there, if I can count, three. Known, it doesn't say known to seller. This is a stretch of the Johnson v. Davis test. It just says known, that materially affect value, that are not readily observable. As a buyer's agent, we can go into this more later, but as a buyer's agent, you now have an affirmative duty to disclose. It was there before, but we didn't have agency agreements, and now this is one of those things where attorneys that are no longer practicing in tort reform are going to be looking for places to practice. And this attorney that I learned of the other day, who's suing realtors, his primary focus is disclosure failures. So the buyer buys, and 6 months later the roof leaks, and they try to find disclosure failures.
So what would you say then if you're a buyer's agent, then you should definitely go get the seller's disclosure from the listing agent, because a lot of, I mean, as a listing
Seller
agent,
disclosures open up a whole nother
I know.
world of hurt, and I would just, my advice to agents is you take the time to figure out, you disclose all the known facts that are not readily observable, that materially affect value. Does a $100 defect affect a $100,000 sale? No. Is that materially affecting the value? No. Does a $1,000 defect materially affect the value of a $100,000 sale? Probably. It certainly doesn't affect the $1 million sale. So there's a whole lot of things in there. We can go over.
I mean, you just need to make sure if you're an agent, your broker now has really good E&O insurance. I mean, right?
I keep saying that to Jim, that like the people that are most exposed in all this are the brokers, especially those big brokerages where the agents are flying loose.
Well, yeah, and the other one are the big brokerages where agents are flying loose, and the small boutique brokerages where a lot of them don't carry E&O insurance. What's up, Chris?
So I guess kind of unpack this, Jim. I mean, to me, if you're a buyer agent, you're probably seeing the property for the first time with your buyer. And most of the things you're pointing out would be verbal. They would not be in writing until you get to home inspection. Third party is going to disclose. Why would you not ask for a seller disclosure if the broker, namely me, is now on the hook?
You could ask for a seller's disclosure. And this is one of the dangers of doing live podcasts. People ask you questions you hadn't contemplated. So I want to fully put a pin in that till I can think about all sides of that. Off the top of my head, a seller's disclosure doesn't sound like a bad idea on this issue. But there's one thing you got to focus on here too. Known facts. So there's three elements that have to be met. All three elements have to be met before the broker is under a duty to disclose. It has to be not readily observable. It has to materially affect value, and it has to be known. You can't disclose, you're not under a
Вот,
duty
они
to
что-то
disclose
рассказывают
things
про
you
эти, про
don't know.
парковки.
So that's a big hurdle. Now that you have the seller's disclosure, now those things are known. I agree with you. It definitely speaks to the issue of transparency and helps get everything out in the open. But let's just say you don't have a seller's disclosure and you don't have knowledge of the defect. Those are typically seller issues. As a buyer's agent, you're not on the hook for the things you don't know. Does that make sense, Chris?
It makes sense to me. I would just say from a practical sense,
Yeah.
there's a lot of things exchanged agent to agent on a showing, or maybe prior to a showing about a roof, a previous leak or whatever. And they're just verbal. And I think many times we just wait for home inspection to kind of paper over it. Where I just see all the verbal back and forth kind of getting us in trouble if
I agree.
it's unhappy.
It'd be nice to get that stuff reduced to a list so so buyers aren't saying, well, you knew.
Yeah.
There's a big part of me that wants you guys to be able to practice efficiently. And there's a ton of lawyers out there that I've listened to on their podcasts. They get a paper for everything. I don't disagree with what you're saying. The other problem is you have buyer's agents, and this used to only pertain to selling agents, where buyer's agents learn of a defect to the property, and you're with buyer A, and now you're with buyer B, and you learned of your defect to the property under your relationship with buyer A. Now you are under an affirmative duty, seller's disclosure or not, to disclose what you know to buyer B. And I see this frequently in the seller agent arena, where you have a seller who says to the agent, hey, they don't like the crack under this is an actual case we did. It was they don't like the huge crack in the floor underneath the carpet in the dining room. Let them cancel during inspections. Well, that buyer A gave them a written report about the settling and the serious nature of the crack. When they did the walkthrough, they pulled the carpets aside and there was this huge crack, and they argued about it. Actually, it wasn't even in the inspection period. And the seller said, let the buyer go. We'll get another buyer. Well, what's the problem with that? Now the seller has knowledge. In the seller's mind, it was just this little crack in the floor. And it didn't need to be disclosed because it was inconsequential. But the buyer went to the extent of getting a huge report, not a huge, but a soils report and all kinds of stuff. And now the seller was on notice of the gravity. That speaks to the issue of materially affecting value. So now, even though the seller cuts the buyer free, the seller is now still under a duty, and the seller's agent, to disclose that to the next buyer. So you don't get over the hurdle. And I always tell the agents that call me on this issue, just tell the seller to own up and deal with buyer A, because you're going to have to disclose this to buyer B. Now, under the buyer agency agreement forms, the buyer who works with multiple buyers on the same property is under the same duties. I would argue they were before, but now it's expressly in writing. Does that clarify things a little bit? Again, I met a lawyer who specializes in suing real estate agents. All right, there's 4 new forms. They're brand new. They're just out. They're the compensation forms that the sellers are going to get that the buyer's agents are going to get signed either with the sellers or the seller's broker or both. Has anybody seen these forms? Speak up. If you haven't, this is a safe zone. Nobody's gonna say anything. If you haven't, here's the forms. All the agents I've talked to are not familiar with the forms. If somebody's familiar with them and you've heard something contrary to what I'm going to tell you guys, definitely speak up. Go ahead.
No, I was going to say, yeah, I mean, I'm aware of these. This would be a great time too, that you could have this compensation agreement, seller to buyer's broker with your offer, right? Because it's not going to be in the MLS anymore, come the 17th of August. And if the listing agent goes, yeah, the seller's going to be paying you 2.5%, wouldn't it be smart, Jim, to have this compensation agreement, seller to buyer's broker, in with your offer, when you send
I
it.
don't think it's a bad idea. I just want to hear from agents, practically speaking, how it shakes out for them. If they like to firm stuff up in communications back and forth and then send the form and memorialize it, or if they want to send the form right off the bat. I don't think it's a bad idea. I just love to hear what agents want to, what they say from a practical perspective. All right, so the forms are pretty straightforward. You're going to get one or the other signed. They all look relatively the same, the only difference being the one you're going to potentially sign with the seller's broker has the ability to put in a name of a buyer if you want. It's optional. They're pretty straightforward. Get them signed after, I would say get them signed after the compensation terms are nailed down. Sellers and sellers agents can keep a master on file. And to Ryan's point, if you're a buyer's agent, keep your buyer's agent side on file too, and just make it a standard part of your practice. I want to hear from agents how they like to work it in. And certainly if you guys have any ideas, I'd like to hear about them. Oh, they're really straightforward. So there's a term section where you talk about the term, and it's going to automatically, if it expires during the term, it automatically extends through closing. That's a very important point. There's the buyer's broker compensation. There's a section where they talk about how much you're going to get paid and how, flat fee or a commission, or a flat fee and a commission. There's an arbitration clause and a miscellaneous clause that's, you know, on standard fair housing and things like that. So they're really short. They're really simple. It's I call it a speed bump, not a hurdle, but I want to hear from you guys how you get them executed. It can be on your website. It can be freely texted, or it can be in your permanent file, Seller's broker form can be buyer specific. We talked about that. There's a Florida Realtors discussion on this. If you want to hear from the Florida Realtors, it's 12 minutes long. There's about 5 minutes in the middle that's relevant. The next form just released. Does anybody have any questions on those forms? Comments or questions? Next form that was just released is the pre-touring agreement. If anybody's seen anything on this, absolutely speak up. It's in your forms library, property pre-touring agreement. I'm going to go out on a limb and I'm going to say this thing is genius. You can get it done quickly. You can get it done easily. It's short, it's relatively pain-free, and it's to the point. Keep it handy. I would say use this to break the ice. It's a super short form. You're just going to fill in some compensation amounts. It has the key language, which says, there's a term in here. There's your language. If you do not owe broker any compensation at this time, if you wish to work with a broker, the purchase of property the broker shows you, broker's compensation for services broker provides will be used as follows. So you have a compensation form in here. If you wish to work with the broker to purchase a property, broker may ask you to sign a separate engagement agreement detailing the parties' responsibilities during the sale. A seller or listing broker may agree to pay some of the broker compensation. If you choose a property already listed by broker, seller may pay broker or services broker performs for seller, and you may be responsible. Broker's compensation form, any source will not exceed the amount of compensation in a written agreement. So you have a length, you have a effective date. The thing that I don't like about this agreement is it doesn't have a holdover provision that says if a contract gets entered into that it's going to extend, and I thought it did. So one of my questions is, once you hit your stride with your buyer's agent, get a buyer's broker agreement that has the full language in it. My question is, what if the buyer never signs the longer buyer broker agreement? I'd suggest the terms of the pre-touring control. It's not extended through the contract. Sorry, you guys, this stuff was hot off the press. I thought there was an extension in here that brought it through the end of the contract. It does not. So that if you went under contract, it automatically extended. It looks like there's a suicide date here, and that's it. The thing that I love about it the most is there's this great disclaimer at the bottom of the form that says, that the Realtors Association makes no representations as to the legal validity or adequacy of the provisions of this form. That blows my mind. I'd suggest you use the terms, the pre-touring agreement. Let's see. So why use the longer form? Oh, so why use the longer form? Why press your buyer to get into the longer form? There are numerous protections in the new buyer's agency form, like the one we talked about earlier, where buyers are given writing notice that they should rely on the opinions of their experts if they're going to have technical questions. And so that can potentially get buyer's agents off the hook for giving incomplete answers or maybe even wrong answers on highly technical questions. Chris, did you have a question?
I think from just a practical standpoint, maybe I just have a comment. From a practical standpoint, I came out of the Maryland, DC market, which a lot of this stuff is what's been going on up there for years, where I look at the pre-touring agreement as kind of a blanket agreement for the number of days you fill in there. And then to me, whatever the compensation is that's being offered or whatever we want to call it by the seller or the seller's agent, I would just have my client initial that and then move to the compensation form and then have them do a compensation form prior to the offer. Or I would go to a buyer broker agreement in the process of writing an offer. Like, to me, this is a great form, which is a really low bar to cross if you're not comfortable doing the full buyer broker in the first meeting.
I agree with everything you said. We got to always look at this stuff with fresh eyes. I've been doing this for 40 years, private practice for 20. I see all these new forms and my head spins, but I agree with everything you said. And I think if we look at this with fresh eyes and we're an agent just coming into the business, we're going to think nothing strange. If we're an agent that's been doing this forever, like myself, or an attorney that's been involved in the space like myself, it seems like a high bar, but I think it'll sort itself out, like you're saying. There's a modification to exclusive buyer broker agreement, showing agreement. Let's see, not sure what I meant by that. I just finished writing this thing. Modification to exclusive. Oh, this is in the wrong section. Before I publish this thing, I will put that out. There's modifications to these forms here, and they're kind of foolish, in my opinion, forms, but they're available if you want to modify the compensation forms that the buyer's agent agrees to with the seller's agent or the seller's broker. There's modification forms available. Topics all agents should know, the Sitzer NAR settlement FAQs. If you guys looked at the FAQs, anybody who says they have, great. I think most people haven't. But if you haven't looked at them, I tried to summarize the ones I think are most relevant for you guys. I gave you the link to the FAQs. These things are changing regularly. So I look at them every few days and I see new ones popping up and I see other ones coming down or even being modified. FAQ 50, MLS participants working with sellers must disclose in conspicuous language the new Sitzer NAR settlement language. That's got to be on all the forms that your agents sign. And moving forward, well, we'll talk about that in a minute. FAQ 52, MLS participants must make this disclosure. Active agreements can either be amended or a separate disclosure can be provided to satisfy the requirement. That was added in June. There's going to be forms available from the Florida Realtors that are going to make this easy. But if you entered into a listing agreement pre-August 17th, then post-August 17th, you're going to want to circulate the addendum, or you're going to want to get that disclosure in front of them. The mandatory Sitzer disclosure. You guys, you have any questions, text me 24/7 and we'll go over this stuff, person by person. The practice change requiring written agreements with buyers is triggered by 2 conditions. I get a text a day on this topic. It only applies to MLS participants working with buyers and is triggered by touring a home. What does it mean to be working with a buyer? Working with language is intended to distinguish MLS participants who provide brokerage services to a buyer, such as identifying potential properties arranging for buyer to tour a property, performing or facilitating negotiations on behalf of the buyer, presenting offers by the buyer or other services to the buyer, from the MLS participants who simply market their services or just talk to a buyer like an open house, or by providing an unrepresented buyer access to a house they have listed. If the MLS participant is only working as an agent or a sub-agent to a seller, then the participant is not working with the buyer. In that scenario, an agreement is not required because the participant is performing work for the seller and not the buyer. That's like open houses and things like that. Authorized dual agents, on the other hand, work with the buyer and the seller. A written agreement, though, is triggered as soon as you tour a home. A written buyer agreement is required to a buyer touring a home. An MLS participant working with a buyer can enter into a written agreement at any point, but must do so no later than the point that they tour the home. So in theory, you can be working with a buyer up until the point you tour a home. Now you need to have the written buyer agreement. And it also applies where the agent has toured the home and they're providing a video to their buyer who is not physically in the home. That's considered touring a home. Everybody follow that? You make a video, you've never taken them through the home, you send it to them, you've officially crossed the threshold, no pun intended, of touring a home. Okay, right here. What defines touring a home? When the buyer or the MLS participant or other agent at the direction of the MLS participant working with the buyer enters the house, or buyer's agent enters the home to provide a live virtual tour. That was the rule I just went over. Rule 60 or FAQ 60, are buyer's agency agreements needed for buyers at open houses? No. In this case, since the MLS participant is only working for the seller and not the buyer, the MLS participant does not need to enter into a written agreement with the buyer. Are written agreements required in a dual agency scenario when a single agent works for both the buyer and the seller? Yes. If an MLS participant is working as an agent for buyer and if an MLS participant is working as an agent for a buyer, a written agreement is required. FAQ 55, who will be responsible for enforcing the written agreements and ensuring all the parties follow the new practice changes? Back to the top of the podcast, all these rules are moot if nobody's enforcing them on some level. I won't say moot as if they don't exist. I'm just going to say, if no one's enforcing them, what are the penalties? What are the enforcement mechanisms? MLS will be responsible for enforcing the rule regarding agreements, like the MLS enforce other existing rules.
Chris has a question. Go ahead.
What's
Chris.
up, Chris?
Hey, Jim, so on 64, we don't do dual agency, right, in the state of Florida. So if I'm representing a seller and a buyer comes in unrepresented, I don't need to do a buyer broker agreement.
If you are performing strictly sales related tasks and your buyer and the buyer is not paying you, so you're performing tasks related, they call it seller's marketing tasks. So let's say you do, I think the scenario you're talking about is like you do a mailer and you say, hey, Chris just got the new listing at 123 Church Street. Everybody in the community, just letting you know, I'm a kick-ass agent. And somebody responds and says, oh, I want to buy, a buyer responds and says, oh, I want to buy that property. And you start talking to them. That would be considered strictly performing seller marketing duties. You would not need a buyer's agency agreement. But
So he's talking about the
collective-
dual agency, but what, let me just
but if you
interject real quick.
collect, but if you're going to collect a fee from the buyer, then you would need an agency agreement with the buyer. Sorry, Ryan, go ahead.
No, there's no the dual agency, but what if you're a transaction broker as a listing agent, which
That's what I'm thinking.
yeah,
Yeah.
And your listing agent allows, and your listing seller, your seller allows you to transition into a transactional broker. Then you would need to have, you're going to get a commission from a buyer. You're going to be doing more work. You need to get compensated by your buyer. You're going to need a buyer's agency agreement.
what if you have it laid out in your listing agreement with the transaction broker that you're getting 2.5%, the buyer broker is getting 2.5%, and then if you're representing both, right, and you're getting 5%, then you would need to have the buyer's broker agreement.
That's a really good question, and I want to butt in really quickly. We just got a file the other day where I want to say Monday or Friday, where the listing agent has both sides, and seems like I didn't see the listing agreement, but he's getting 5%, which in which the seller is paying. He then sends a follow-up email, or in the same email says the buyer will be paying him 0.5%. So he had an agreement with the listing agent, and the listing agent's going to pay him 5%. However, he's getting the buyer to pay him another 0.5%. So he's getting 3% representing the buyer, and then 2.5% from the seller.
So he's gonna get, okay,
Do you get what I'm
so,
saying?
so the seller's paying 5, and they're
Correct.
paying 2.5 to the selling agent, 2.5 to the buying agent, and now the buyer is chipping in 0.5 to the buyer's agent.
Correct.
And
Which
he's
is all the
both.
same agent.
Yeah, he's the transaction.
Oh, and it's all the same
Right.
agent. I missed
Yeah.
that.
Yep.
You're gonna need a whole.
I mean, that's like, do you need to have the buyer's broker? I guess you would. You would
Yeah.
need then as the transaction broker to have the buyer's broker.
And I think agents will even get
Fine.
more greedy than that. If you have a buyer that doesn't know any better, you can get the seller to pay you 5% and the buyer to pay you another 3%. You know,
think about
it's
it,
whatever you get people to agree.
Well, that's what I mean.
to.
Yeah, the leverage now with the listing agent, if he gets a direct buyer, I mean, he could be saying, hey, if you really want this, you're going to have to, I mean, it's a rabbit hole.
It's a rabbit hole. It is a rabbit hole. But I think to Tajay's point, there's room for a lot of creativity. And you got to think in your mind, if you're collecting compensation from a buyer, it has to be memorialized in a buyer agreement.
Yep.
And the buyer has to understand their role and your duties to the buyer.
But I guess there's nothing that says that a transaction broker listing agent can't get an additional fee from the buyer that's more than the listing agreement, that's spelled out in the listing agreement. It is
And
spelled out in the
that
buyer's.
begs the really interesting question.
Yeah.
That what if your seller's listing agent says no?
Yeah.
Because in theory, you're not allowed to collect more than is listed in your listing agreement. So if your listing agreement says 2.5 from buyer's agent and 2.5 from seller's agent in your listing agreement, and then you go out, the new listing agreement forms are going to be interesting.
Yeah,
That's
we
a
don't
whole
know until we
other-
see that. It might
yeah,
have
that's a
the
whole
language
other
in there.
topic.
Yeah.
It's
The
gonna
new buyer's
appear,
broker agreement says it in there. It can't exceed what your buyer's broker commission is. So if it's 3%, you can't get 4% from the seller.
but the compensation
Now-
is gonna show on the settlement statement, right?
It'll show on the settlement statement. And then in theory, you got to get the buyer's broker compensation forms filled out by seller or seller's broker. Showing
And
where
we just did another one. It closed on Friday, and the buyers show up to closing. They're paying 0.75. The buyer's agent got 2.25 from the seller, and then the buyers are paying 0.75, and they signed saying they're paying 0.75. When they show up at the closing table, someone in our office is signing them. The husband's highly upset because he's like, I had no idea that my wife agreed to us. He started blaming his wife that she agreed to us paying 0.75% of the sales price.
Well,
And that's at the closing table.
So
I
we
mean,
got
it's not
cleared. So
signed by
that,
both parties. I mean, is it enforceable?
well, that was the one that I gave you guys the example of earlier in the conversation, earlier in the discussion, where we got clear DAs, but I didn't hear the wrinkle until just now from Tajay, how at the closing table, the buyer was giving friction over the agreements. That's interesting.
I mean, there can be a whole law practice that's going to come out of this, right? Just to straighten these things out. I could see in the future.
But who's gonna? I don't see it happening in the compensation arena. I see it happening more in the arena that already existed, which is the seller's disclosure and the agent disclosure arenas. I don't see it. I don't see cases being sued over or claims being lodged in the compensation forums. Does that make sense? I don't think we're advancing to that.
Yeah.
I don't think we're advancing there. I think we're just, it's more disclosure issues, and the one we talked about earlier with the exclusive buyers comp form where it's talking about once the buyer's agent has knowledge, they have to share it with other buyers, future buyers. That's always existed. It's just now it's memorialized. You guys, I hate parting company with or leaving a topic with confusion. If their buyer's agent is paying, if the buyer is paying the buyer's agent money, if they're putting money in their pocket, you need to have a buyer's agency form. It's as simple as that, no matter who you are in the transaction.
And you got to make sure your buyer, a big thing that I just keep thinking about is you have to make sure your buyer can actually afford to pay you a commission, right? You have to talk to the loan officer like, hey, if my buyer has to pay me 2.5% or 3%, do they still qualify for this loan? It's like, I think for a normal transaction, right? Not if you're some big buyer that's buying an expensive property, but for a normal $500,000 home, that's a real conversation. Can they actually afford to pay a commission?
Yep. 100% agree.
Compensation. I mean, so just to reiterate, let's put a bow on this here. The enforcement is going to be on the MLS for these agreements,
Yeah.
right? They haven't put out any kind of fines or anything like that of what they're going to do, right?
Not
But
that
they're
I'm
not.
aware of.
Yeah, they're not
It's
requiring.
July 30th, 2024. Not that I'm aware of.
Yeah. So there you go.
Yeah, and it doesn't provide for, I have to think about a further private causes of action, private remedies, things like that. Got caught
Awesome.
up being silent. I couldn't draw him into any of these conversations.
Wow, Jim, thank you for doing this. I mean, this is in depth to have an attorney's perspective on this. I mean, like I said, this is all brand new, guys. This is all within the last couple of weeks of all this coming out.
Couple days. Some of this
Yeah,
stuff is
actually,
48
yeah, a
hours
couple
old.
days, and it's going to be living, and we're going to do more webinars as more stuff comes out. Provide awesome information to us agents, right, and let us, get through this transition as easy as we can. It's not easy. Again, I want to speak really good things about Jim with New Path Title. I use him for all my closings if I'm the listing agent here in Palm Beach, because obviously the seller picks title, and his awesome closing where a Title Leap is amazing. It is like a free contract coordinator. And I do want to reiterate, especially now with everything that's coming down here, is Title Advance, which is the free, like a title search light that agents get for free from Jim in his office. You can touch on that. But here, Jim, thanks for showing Real Trade. Real
I
Trade
love
is
the
real
site
estate
revamp,
social.
Ryan. Yeah.
Yeah,
I like the
we've got
site
our
revamp.
premium agent out. We've been doing some updates to the site. Again, agents, register for Real Trade. If you haven't, you get free leads off your listings. Buyers or sellers can discover you too by searching out agents. You can post on the social, promote your listings. It's free for agents, doesn't cost anything. You can also get connected with awesome service providers like Jim. Jeff Stewart's on this call. He's a lender. He's active on the site offering awesome lending tips. So it's a great place to not only get connected with buyers and sellers for free, sell your properties quicker and get connected with awesome service providers like
And it's
Jim.
the home of the double dip, right?
Yeah,
You're a
no, for
seller
sure.
on here. You have a good opportunity to meet a buyer directly. And as this new issue sorts out on the topic of pocket listings, I think platforms like Real Trade are going to become more and more valuable.
Yeah, no,
I think
it's going to be
platforms like Real Trade are a great place to display seller concessions on buyer brokerage fees. I think it'd be a great go-to where you can just easily get on there and you can't list it in the MLS, but there's no reason why it can't be posted in Real Trade. I hate bringing up
yeah, no, there's different things you can do, but yeah, no, check it out if you get some time. But go ahead, Jim. Why don't you talk about Title Leap and
yeah, you guys want to close with us, you're going to get Title Leap, your buyers and your sellers. Just make it so much easier. They're not buzzing your phone all the time, ringing your phone off the hook. You can go to newpathtitle.com and you can send us contracts. New Path Title. It's easy to do. Just click send us a contract. You can get 24/7 attorney support. Text me by clicking here. And as always, this is the best part of my week. It's a pleasure talking to you guys.
well, thanks, Jim. Thanks everybody for attending. See you
All
the
right.
next one. All right.
Clifton, if you have any questions, text me. I'd love to answer them.